Afternoon, everyone. I'm Robert Golin. I'm a barrister at Farrar's building. I have a mixed civil practice, mostly in personal injury and employment law. And this is the latest in a series of webinars. Last week, we had an update on credit hire from Grant Goodlad and Amelia Heinem. All of our webinars are available on our website. There's a section called Knowledge Base. And just to let you know that a recording of today's webinar will be sent to you automatically. It's probably going to be tomorrow. It takes about 24 hours to actually publish it. So just wait for that to appear in your inbox. I'm going to talk about motor claims involving children, and Tom Emsley-Smith is then going to talk about motorbikes and bicycles. And just to let you know, you should be able to type in any questions you have as we're going along. And if we have time at the end, we'll do our best to answer as many as we can. And what I'm going to do now is try and share my screen so that you can see my PowerPoint slides. And I'd ask Tom if you could just wave at me if this doesn't work, but hopefully it does. Excellent. So what we're going to cover today are issues including some general principles of contributory negligence, and then some common scenarios, so pavement cases, seatbelt cases, parental supervision of children, and then some procedural issues, including expert evidence, hearing evidence from children in court, and fundamental dishonesty in child cases. And this is certainly not a deep review of the law of contributory negligence. I'm going to try and stick to relevance to children, but it's useful to at least note that it's almost 20 years since the Court of Appeal in 2 cases took a firm stance against drivers in the context of collisions with vulnerable road users. So in Lunton Khalifa, the court described cars as potentially dangerous weapons. In Eagle and Chambers, the court emphasised the destructive disparity between vehicles and pedestrians. And the Court of Appeal stressed that it would be rare for a pedestrian to be found more to blame than a driver, unless, of course, the pedestrian has suddenly walked or run out into the path of a car. Nevertheless, predicting the apportionment is, or appears to be, harder than it looks for first instance judges. And you don't have to look much further than Jackson and Murray, which was a Scottish case, but it worked its way up through the appeal courts to the Supreme Court. And very briefly, I'm not going to linger on the facts, but just to give you an idea, the claimant was a 13-year-old girl. She got off a school minibus on her way home. She walked behind the minibus, poked her head out, decided to at first walk across the road, and then she ran across the road. And the defendant, who was driving in the opposite direction at about 50 miles an hour in a 60 mile an hour zone, hit her. And at first instance, the judge found that the claimant child was 90% to blame. On appeal, 70%. And then the Supreme Court reduced the child's negligence to 50, or the apportionment to 50%. But that was only by a bare majority. Lord Hodge and Lord Wilson said they didn't think that the appeal court had made an obviously wrong decision. They wouldn't have disturbed it, but if they had had their own stab at apportioning it, it would have been 66%. Typically, when it comes to contributory negligence, the court applies an objective standard. So the court does not have regard to individual characteristics. Someone may be not a very skilled driver, for example, a learner driver. This is the classic case. But the law applies the same standards to the learner driver as in everyone else. But the well-established exception to this is age, and the classic statement of principle is in a case called Goffenthorn. And here is what Sam and LJ said. What I want you to concentrate on is the bit in italics. So the question as to whether a plaintiff can be said to be guilty of contributory negligence depends on whether any ordinary child of 13 and a half can be expected to have done any more than this than the child did. I say any ordinary child. I do not mean a paragon of prudence, nor do I mean a scatterbrained child, but the ordinary girl of 13 and a half. So really, there are no fixed rules as to as to the age and in what circumstances a child will be found guilty of contributory negligence. Generally speaking, the assessment is done by the trial judge doing his or her best, and one can see how this leaves the door open to uncertainty, as different judges may have different views as to capacity of children at different stages in their life. But are there any patterns? Well, firstly, it's worth noting that this is extremely fact sensitive, but up to the ages of about 6 to 8, roughly, findings of contrib are rare. By the age of about 13, reductions are more likely. Sizable reductions are more likely, I should say. And by the age of about 16, judges are more likely to treat children as similar standards to an adult. And what we're going to do now is move on to a series of types of cases. So pavement cases to begin with, and I'm sure from this picture you can all imagine what's going to happen next. But this is a Scottish case again called White and Bluebird. School children jostling around at a bus stop. The child's feet were on the curb, but the upper part of his body was leaning into the road. A bus pulled into the bus stop, close to the curb but not overhanging it, and a boy was hit. And the court rejected the defendant's arguments for contributory negligence. The court found that the claimant was wholly on the pavement, was entitled not to be struck by a vehicle, and there was no room, especially in view of his age. But just so you know, it's not just age that's a factor here. The finding in the Bluebird case is consistent with a prior case called Chapman and Post Office. And this is quite old now, but Lord Denning said he saw no reason why a person standing on the curb is guilty of negligence at all, even if, and this is perhaps the surprising bit, even if she leans out or has her back turned to the oncoming traffic. Even if she went an inch or two into the roadway, I cannot see that would amount to negligence in the slightest. And again, that may seem a little surprising, but it's been followed recently for an adult claimant in a case. It's not included here, but the case is called Osei Antwi and South East London and Kent Bus Company Limited. And in that case, claimant's counsel invited the Court of Appeal to say whether Chapman, so Chapman and Post Office, constituted a general principle that a pedestrian can never be negligent or never be held to blame partially when standing on a pavement. And unfortunately, the Court of Appeal declined to make any general statements such as that. But my comment is it seems likely that there would need to be something truly exceptional or unusual about the facts of the case for a defendant to succeed in a pavement type situation. Let's move on to seatbelt cases. And the question really is, to what extent can a parent be responsible for injuries or a driver suffered by a child travelling with the wrong type of child restraint? And the most recent application of this is in a single case. I'll explain why in a moment. A single case with 2 citations in Northern Ireland. And I'll just go back one step. The reason there are 2 citations is that there was an initial trial before one judge. It became clear that one of the experts had come to his opinion on documents that weren't before the court. So the first judge dealt with liability, adjourned the case until those extra documents were available. But then on the second time, that first judge wasn't available, so a different judge dealt with it. And the facts were a 2-year-old passenger was in a car driven by her paternal aunt, D1. She was placed in an unsuitable booster seat because of weight. The booster seat ought to have had a 5-point harness, but instead the seatbelt was placed over the shoulder, and the child suffered spinal cord injuries causing tetraplegia. And in that case, the driver of the car was found to be negligent for using, number one, an unsuitable child seat because of weight of the child, but also an unsafe position of the seatbelt. And really the crux of the matter was, what difference would a suitable seat have made? And the judge found, and this was based on expert evidence for both parties, that with proper restraints, the claimant would not have sustained the spinal cord injury leading to tetraplegia, but nevertheless would have sustained injuries to the upper cervical spine of less severity. And so how did the judge deal with this situation? I'm sure you'll be familiar with the case of Froome and Butcher, which relates to the use of seatbelts. And the judge found that although the issue of contribution failed to be determined under the 1978 Act, that the Froome guidance should be applied. The judge found that had it not been for the driver's negligence, the spinal injuries would have been substantially lessened, and there wouldn't have been the catastrophic injury of spinal cord injury. And so the contribution from the driver was 25%. And in terms of comment on this, the adoption of the Froome guidance is consistent with an earlier Court of Appeal case called Williams and Williams. As to whether there should be a reduction of 25% or whether it should be lower than that, really the difference in the focus is likely to be on what injury, if any, would have been suffered if the correct equipment had been used. So for example, if it would have made less of a difference, then you might see a reduction of maybe only 15%. Certainly those are the figures that were suggested in Froome. Parental supervision. So the question is this: if an unsupervised child is too young to be found contributory negligent when crossing a road unsafely, should his parents bear some responsibility for allowing the child to be out on his own? And these were the facts in a case called Ellis and Kelly. In that case, a child was aged between 8 and 9 and was knocked down by a car driven by a Mr. Kelly and suffered a severe TBI. The claimant's mother, Mrs. Ellis, had allowed the claimant, so allowed the 8-year-old to go out with some family members who were also themselves children between 7 and 10. They went to a playground, and one of the children left the playground, and the claimant decided to follow by himself a bit later on, walked out into a road and was hit by Mr. Kelly. And Mr. Kelly's insurers admitted primary liability, but argued for two things: so contributory negligence on the child's part, but also a contribution from the child's mother for allowing the child to go out without proper supervision. And there are two main sections to the judgment, one dealing with contrib and the other dealing with the contribution from the parents. And as to contributory negligence, the judge said no, it wouldn't be just and equitable. It was a momentary misjudgment on the part of an 8-year-old who encountered a reckless driver driving at more than 40 miles an hour in a 20-mile-an-hour zone. And Mr. Kelly's standard of driving was outside the child's expectation of drivers based on his limited understanding and experience. But even if the speed, for example, had been lower, it seems unlikely that an 8-year-old child would have been found contributory negligence. But how about the contribution claim against the mother? Well, this was also dismissed, and the judge found that it would impose far too high a standard on an ordinary parent making ordinary decisions in the course of parenting as to how to keep a child reasonably safe whilst gradually being allowed more responsibilities and freedom. And the judge took into account some policy considerations too. The undesirable nature of regulating decisions arising in the course of normal parenting, so just day-to-day parenting. The inability of parents to secure insurance to guard against the risk of claims arising out of their own parenting decisions. The real risk of encountering or encouraging over cautious parenting if the contribution claim was allowed. but also the impact it would have on litigation. So conflicts of interest between a parent litigation friend, for example, and the child, which would delay matters, but perhaps also make settlement less likely. What I'm going to look at now is some procedural issues, and we're going to deal with expert evidence, hearing evidence from children in court, and then very quickly on fundamental dishonesty. In terms of expert evidence, and here I mean the court hearing evidence from an expert as to a child of a particular age's perception of risk. So expert evidence assisting with the issue of contributory negligence in a child case. The only case I could find was a Scottish case called Morton and Glasgow. And in that case, the claimant was 14 years old, and the claimant called evidence from a child psychologist as to the ready propensity of children of 14 years old to indulge in risky activities without applying their minds to the degree of risk involved. And in that case, a child had climbed up some scaffolding that wasn't properly protected, fell off, sustained an injury, but the claimant's argument was that there should be no contributory negligence because of the expert evidence going to the ready propensity of children to indulge in such risks. I think in that case, the court rejected that and found 25% contributory negligence. And in my view, this is unlikely to assist in most cases. I think judges are most likely, in the vast majority of cases, to be able to make assessments on contrib themselves, except maybe at key developmental boundaries. So at the beginning, when we were looking for patterns, I suggested that it's rare for children of more than 6 to 8 to be found contributory negligent. By the age of about 13, it's different. And it may be in those hinterlands, in the hinterlands between those two ages, that there might be more assistance in expert evidence. How about hearing evidence from children in court? Well, the criminal and family courts have developed sophisticated rules for dealing with vulnerable witnesses, but the civil courts haven't, unfortunately. But there's no rule preventing a child from giving evidence in civil proceedings. That's the starting point. But there's relatively little guidance. And really, you're going to be looking at the overriding objective, the court's duty to actively manage cases, and judicial discretion under Part 32 of the CPR, and also the court's general case management powers. And what I would suggest is that where it's not obvious, and certainly directions questionnaires don't allow you to, there's no specific box for indicating this, but where it's not obvious that you might want to hear a child's evidence, that you identify it as an issue as early as possible, that you explain why the child's evidence is relevant, why it's in accordance with the overriding objective to hear the evidence of the child, and to propose safeguards subject to the court's approval for the court to actually deal with this issue without doing any harm to the child. For example, finding out what the child's views are about this, what would make them most comfortable, hearing the child's evidence in private without everyone else in court, and maybe proposing that the judge or some other independent intermediary is there to object or suggest when a question could be rephrased. Finally, fundamental dishonesty. Certainly this is not, and we don't have time today for an in-depth look at fundamental dishonesty, but there are some issues that might be common to child cases. Firstly, there's going to be the disapplication of quox under Part 44.16 of the CPR if the claim as a whole is dishonest. And an example of this might be a phantom passenger case where the claimant is a child. And what you might find is some judicial reluctance to permit, because the defendant would have to seek permission for an enforceable cost order. And there might be some judicial reluctance to permit enforcement of costs against a litigation friend, especially, for example, if it's an innocent relative, a grandmother, for example, where where it might be the parent of the child who has done the dirty deed, but the litigation friend is one step removed from the dishonesty. And the response to that, and really the key point, is that the certificate of suitability that a litigation friend has to sign requires a litigation friend to make an undertaking to pay any costs order made against the claimant. So really, in my view, there is no escape, even in cases where the litigation friend is innocent in the dishonesty. Slightly more difficult is section 57. So if in a situation where the claim succeeds, but the defendant seeks to strike out the whole claim on the basis that it's been tainted with dishonesty. So there's a genuine element, but also a dishonest element. It seems unlikely on the face of it that a child claimant would be the perpetrator of the dishonesty in those sort of situations. But the question is, does section 57 and its use of the word and the necessity for the claimant to be dishonest, does that catch a litigation friend? Again, this very much depends on the circumstances, but my view is yes, or at least it should. The litigation friend, and certainly the historic use of the litigation friend, is that the litigation friend stands in the claimant's shoes in the litigation. But also it prevents a mischief to the rule by the claimant or the dishonest party adopting an over-technical reading of section 57 in order to avoid the consequences. So in my view, most courts would apply a section 57, apply reading to it that prevents the claimant from recovering dishonestly obtained damages. So I hope that's useful. I think now we're going to move over to Tom. And so what I'm going to do is stop sharing my screen, and then Tom can start sharing his screen, and then we'll have some questions at the end. Thank you.
Great. Rob, can you hear me and see the slides? You just give
Yes, I can, Tom. You're good to go.
Great. Well, thank you very much, Rob. My name's Tom Emsley-Smith, and I'm a junior with Farrar, with a mixed civil law practice, specialising in personal injury. In my part of the talk, I'm going to be covering cyclists and motorcyclists. So first of all, I'm going to be looking at whether vulnerability of the cyclist or the motorcyclist is a factor that should be taken into account when assessing contrib, and then looking at helmets and safety clothing, and then moving on to look at the effect of illegal riding on a claim. So cyclists and motorcyclists have accidents relatively commonly, and what these statistics show us is that when they do happen, they tend to be worse. So bearing in mind that motorcyclists make up 3% of the vehicles that are registered on UK roads, what we have here is the DFT statistics for casualties on the road. And cyclists and motorcyclists both make up an 11% share of the casualties. If we then look at the casualties where the person was killed or seriously injured, for cyclists, there's a 14% share of all these casualties. And for motorcyclists, it's 21% of all people who were killed and seriously injured on the roads. So all this goes to show that they have more accidents and they're more likely to get hurt. If you go on YouTube, you can find plenty of videos of what's really the classic scenario involving a cyclist or a motorcyclist, and that's the filtering accident. And if you do any kind of motor work, you'll no doubt be familiar with this kind of scenario, which is where there's a line of slow-moving traffic and a cyclist or a motorcyclist is either using the opposite lane or the side of the lane in which the traffic is occupying to go up the side of the line of vehicles, and a car turns out to the right out of the line or emerges from a side street and knocks the cyclist off their bike. I've got a video of this occurring, so hopefully this works. I'm going to give you some running commentary. It was a little hard to see earlier on. So we have the motorcyclist traveling up the road and he's starting to overtake, and out of the queue of vehicles comes a car and knocks him off his bike. Let's just start that again from the beginning so you can see it again. So here we have the motorcyclist. He's currently following the line of traffic, following a white van and going at the same speed as him. He's just beginning to accelerate and pass the cars on his left, and out of the queue comes the blue vehicle turning right and knocks him off his bike. So it's a fairly common scenario involving a motorcyclist. The blue car that pulled out of that line of traffic is pretty obviously in breach of duty. We can see here in Rule 211 of the Highway Code just one example of where the Highway Code puts a duty on motorists to be aware of the possibility of filtering motorcyclists. It says be especially careful when turning right, when changing direction or lane, and be sure to check mirrors and blind spots carefully. However, we could ask whether the motorcyclist was also in breach of duty and whether there's a reduction to be had for contributory negligence. So the court would be looking at things like whether the motorcyclist would be traveling too fast for the conditions. And that's too fast for the conditions, not just whether he's under the speed limit. So considering the weather, the lighting conditions, motorcyclists would genuinely be expected to travel far below the speed limit if conducting a filtering maneuver. There's also been reported cases where motorcyclists have been criticised for failing to spot indications that a car might be turning to the right out of the queue of traffic. So for example, has the motorcyclist failed to spot the car's indication, or has the motorcyclist failed to see a gap in the traffic where a car might be emerging, and that might be a telltale sign. So these are all fairly standard considerations when you're looking at a filtering scenario, and things that the court would be looking at quite carefully in most of these cases. Slightly more contentious is whether the motorcyclist or the cyclist's vulnerability should be a factor that affects the weighting of contributory negligence, a portion between the motorcyclist and the car driver. If we look at Rule 160 of the Highway Code, it says that car drivers should be particularly careful for cycles and motorcycles. And that's for two reasons. One is that they're difficult to see, but the second is that they're particularly vulnerable. So that rule certainly suggests that the vulnerability of the motorcyclist puts a higher duty on the car to take care of them. Now, there's been a line of cases considering whether that is indeed a factor that the court should take into account. You'll recall Eagle and Chambers that Rob referred to right at the start of his part of the talk. And there, Lady Hale said that a car can do so much more damage to a person than a person can usually do to a car. The potential destructive disparity between the parties can readily be taken into account as an aspect of blameworthiness. So from that case, we can see that this concept of destructive disparity clearly has application between a pedestrian and a car. But does it apply between two road users, so a car and a motorcyclist who is on a mechanically propelled vehicle? Well, the first authority to consider is Woodham and J.M. Turner. In this case, the claimant was a motorcyclist, and he collided with a school bus that was turning out of a secondary road. And what the Court of Appeal said was that there was no reason to hold that the school bus was any more at fault than the motorcyclist. And so they said it was 50% contributory negligence. And that's significant because it was in the Court of Appeal, and the vulnerability of the motorcyclist wasn't taken into account as a factor by that court. Next authority is Jones and Lawton. In that case, Mr. Jones, the motorcyclist, was riding up the side of a line of traffic, and Mr. Lawton emerged from a side road, and the two vehicles collided, and Mr. Jones had to have his leg amputated. Mr. Lawton, the judge found, didn't even consider the possibility that a motorcyclist would be going down the road, and he emerged quickly. But for his part, Mr. Jones was traveling far too fast. And what Mr. Justice Burnett said was that the responsibility for the accident was evenly matched. There were two factors that tipped the balance in favour of Mr. Jones. One was that Mr. Lawton had crossed his path and not the other way around. But the second was that Mr. Jones was a motorcyclist and he was particularly vulnerable as a road user. So destructive disparity was taken into account in that case in the High Court. We then come to two cases, also in the High Court, in front of Master Davidson. The first is Hernandez and Acar. Mr. Acar emerged from a side road into Mr. Hernandez's path. Now, the speed limit was 30 miles an hour, and Mr. Hernandez on his motorbike was doing 50 miles an hour. And Master Davidson followed the approach of Jones and Lawton. He said that there was broad symmetry in the responsibility for this accident, but the vulnerability of the motorcyclist tipped the balance in the favour of Mr. Hernandez. So he said that the apportionment of responsibility was 60-40 in favour of Mr. Hernandez, partly because of his vulnerability. However, the final case in this line of authorities is Stark and Liddon. And this was also in front of Master Davidson. Ms. Liddon had just enjoyed a nice lunch at the Toby Carvery, and she came to come out of the car park and turned to the right out of the car park across Buster Stark's path when he was on his motorbike. And Buster T-boned Ms. Liddon's vehicle, and he was knocked off his bike and lost all the function in his arm. Now, prior to this accident, Buster had been seen to be riding his motorbike round in circles in a car park and revving his engine. And in that witness's words, he was driving like a prat. Just before the collision, he was going at 68 miles an hour in a 30 zone, and he hit the car at 55 miles an hour. Now, Master Davidson, in closing argument, he was taken to an inconsistency in the first case that we looked at, which was Woodham in the Court of Appeal, where the vulnerability of the motorcyclist was not taken into account as a factor, and Jones and Lawton in the High Court, where it was. And Master Davidson said, well, in neither of these cases did they hear very much argument on the point. But he said, putting aside the rules of precedent, would prefer the approach in Jones and Lawton. So Master Davidson said he would hold that vulnerability is a factor that affects apportionment. But he didn't really have to decide the point because of what he went on to say. So bearing in mind the case of Hernandez, which was the same year, same judge, and on very similar facts, we had a speeding motorcyclist and a car turning to the right across his path. And in that case, Master Davidson said it was 60-40 in favour of the motorcyclist. Well, in this case, Master Davidson said, in my view, the causative disparity, that's the destructive disparity, in this type of accident must be regarded as diminishing in line with the excessive speed of the motorcyclist. So Buster Stark's speed was over double the limit, grossly excessive for the circumstances, and calculated in the sense that he was deliberately racing. And so he said that actually the destructive disparity was virtually irrelevant in relation to what really mattered, which was Buster Stark's deliberate, grossly excessive speed. So essentially, if we're following Master Davidson's approach, if you're going really fast, then destructive disparity would be a factor that affects the apportionment. But if you're going really, really fast, and that's a calculated decision, then it's virtually irrelevant. But from that line of cases, in terms of comment, it does seem that there'd be a fairly good argument that the vulnerability of the motorcyclist should be a factor where, all other things being equal, the apportionment should tip in the balance of the motorcyclist due to their vulnerability. And if you had a case involving a cyclist rather than a motorcyclist, I would have thought you'd have an even better argument to say that the vulnerability of the cyclist should be a factor taken into account, because there's a closer analogy between a pedestrian and a cyclist as a pedestrian and a motorcyclist. Moving on from that issue then, going to look at helmets and clothing and the role that they might play in the assessment of contributory negligence. We have here two of the rules in the Highway Code that deal with helmets and clothing. Rule 59 says that cyclists should wear a cycle helmet which conforms to current regulations, is the correct size, and is securely fastened. And for motorcyclists, this is a legal requirement. So the Highway Code says that they must wear a protective helmet, except if you're a follower of the Sikh religion, in which case there's an exception. Helmets must also comply with regulations, and they must be secured, fastened securely. Capps and Miller is authority that failure to wear a helmet is negligent. And what they said in Capps and Miller was that the Froome and Butcher guidance applies in terms of the apportionment. They essentially lifted that from Seatbelt Cases straight on to the failure to wear a helmet. So if wearing a helmet wouldn't have made a difference, then there's no deduction for contributory negligence. A considerable difference, it's about 15%, and if it would have prevented the damage altogether, then there's a 25% deduction for contributory negligence. In that case, the motorcyclist was wearing a helmet, but it wasn't properly fastened. And the Court of Appeal said by a majority that if a helmet is worn but not fastened, then a lesser apportionment of responsibility is appropriate. However, that was a 1989 case, and it's since become a legal requirement to fasten the helmet, as we saw with the Highway Code. That came into force in 1998 under the regulations that you can see at the bottom there. So for my money, you wouldn't be able to rely on that part of the judgment anymore. If a motorcyclist wasn't wearing a helmet properly, then there'd be a good argument that the Froome and Butcher guidance should apply as it's given in Froome and Butcher, as if the motorcyclist wasn't wearing a helmet at all. So that's the law for motorcycle helmets, but what about cycling helmets? Here the issue is a little bit more complex because since they were invented, cycling helmets, well, the debate has raged about whether cycling helmets are actually effective in preventing head injuries. So on the slide, you have the abstract of a famous paper by Ian Walker, who's a psychologist. And he argues that, in fact, what helmets do is make accidents more likely because cars give you less room to go past. And the abstract in this paper in Accident Analysis and Prevention was wearing a helmet, a bicycle helmet, led to traffic getting significantly closer when overtaking. Professional drivers of large vehicles were particularly likely to leave narrow safety margins. Finally, when the male experimenter wore a long wig so that he appeared female from behind, drivers left more space when passing. So many people are unconvinced that helmets really keep us safe. Another example is Cycling UK, the campaign group for the promotion of cycling, actively campaigns against the legal compulsion to wear a helmet. They are neutral as to whether helmets prevent head injuries, but they say that the health effects of cycling outweigh any benefit to making people wear helmets by law. Well, the legal position is set out in a case called Smith and Finch, and that says very clearly that failure to wear a helmet is negligent. So don't go calling Ian Waller to give expert evidence to try and argue that it's reasonable not to wear a helmet. However, that's not the end of the story, because what that case also said is that the Froome and Butcher guidance also applies to failure to wear a cycling helmet. So if the cycling helmet would not have made a difference, then there will be no reduction for contributory negligence. And in that case, the claimant hit the ground at a speed greater than 12 miles an hour. And so the evidence was that given that he was going faster than that, the helmet wouldn't have prevented the injury. So it seems from those facts, it might be quite easy in some cases to show that a helmet would not have prevented the brain damage that's occurred when there's been a serious collision. What the case teaches us, though, also is that you must have expert medical evidence if you wish to contend for a reduction for contributory negligence for not wearing a helmet. The burden of proof is on the defendant, and the defendant needs to show that a helmet would have made a difference. In Smith and Finch, both of the parties called two crash helmet experts, and the judge says that there was no evidence that the brain damage wasn't caused by the rotation injury when the claimant was hit by the motorbike, rather than when he landed and hit his head on the pavement. And he said that that was a fundamental evidential omission. You need a medically trained professional to give expert evidence to comment on the causation of the injuries. Otherwise, there'll be no evidence that it would have made a difference and no reduction. The third point I want to look at is what if the cyclist or the motorcyclist commits a crime? What effect will that have on the outcome of your case? Now, most of the offences in the Road Traffic Act of 1988 apply equally to a motorcyclist as it would to a car. So you have two examples there on the slide. There's firstly the offence of dangerous driving, and the secondly, careless and inconsiderate driving. Both apply to people who drive mechanically propelled vehicles. With cycling, the landscape is far less regulated. However, there are a number of offences that cyclists can commit on the roads. So dangerous cycling and careless and inconsiderate cycling, these are exactly the same tests as the mechanically propelled vehicle offences. Cycling whilst under the influence of drugs has its own offence under the Road Traffic Act. Cycling on the pavement has been illegal since 1853. Wanton and furious cycling is another offence that hits the headlines every so often. You may well remember a few years ago the high-profile conviction of a cyclist who'd caused serious injuries to someone while wantonly and furiously cycling. And this is my personal favourite at the bottom of the slide. Holding on to a moving vehicle while cycling is an offence under section 26 of the Road Traffic Act. So I've got a video here. It's an offence to do what this man's doing. So, not legal. If a cyclist or a motorcyclist does commit an offence, how might it affect your case then? Well, the first point to make is that any illegality falling short of dangerous driving is unlikely to give you a complete defense. That's made clear in case of Clark and Farley, which we'll consider in a minute, because turpitude or illegality needs to be sufficiently serious in order for the maxim of ex turpi causa to apply. So if it's dangerous driving, then maybe, if the facts are right, if it's anything less, like careless or inconsiderate driving, or something that isn't relevant to the standard of care, like document offences or failing to stop, that's unlikely to give you a complete defence. However, if there is evidence that a party has been convicted, and that conviction is something that's relevant to the standard of care or the standard of driving, like careless and inconsiderate driving, that is admissible as evidence, and that founds a rebuttable presumption that the offence has in fact been committed. So that's very powerful evidence to prove that the motorcyclist or the cyclist has been driving negligently, as you allege. And the commission of an offence, like careless cycling or like dangerous cycling, I've said will weigh heavily, but it's likely to weigh heavily when assessing contributory fault. I had a case a few years back where my client was a pedestrian who had stepped out in front of a cyclist who had come careering down a hill and had hit her very hard. My client was badly brain damaged and couldn't give evidence. And the cyclist had sued her essentially for his injuries, because his case was that she stepped off the pavement in front of me when I was cycling down the road. Now, he had been convicted with careless and inconsiderate cycling, and the judge said that he was entitled to damages, but he made a reduction of 80% conviction evidence. And I think the conviction weighed very heavily on the judge's mind. So that can be a very powerful factor in terms of that issue. Fourthly, don't forget that evidence from police investigations and criminal proceedings is extremely helpful before the courts when assessing responsibility for the accident. So particularly for the claimant, get hold of the police investigations, transcripts of interviews, any notes that you can take from the trial are also helpful, and the indictment. These would all be admissible and would be of great assistance in the court in assessing fault and in assessing contributory fault. As I close, I want to give consideration to a few instances where illegality will afford a complete defence to the defendant. And these are cases where the claimant has been involved in a joint criminal enterprise of dangerous driving by being a pillion passenger on the back of a motorcycle that's being ridden dangerously. The first case is Pitt and Hunt. In that case, two young men had been to a disco and they got drunk and came out of the disco and got on Mr. Hunt's motorcycle. Now, Mr. Pint was equally drunk. He knew that Mr. Hunt was drunk. He knew that he was unlicensed and uninsured. And they got on the motorcycle and they started weaving in and out of the white lines on the road and shouting yippee in order to scare other road users. And it was found that the claimant was actively encouraging the dangerous driving. And unsurprisingly, the motorcycle crashed and the defendant was killed. The claimant sustained serious injuries. The court found that the claimant's conduct was sufficiently serious to engage the maxim ex turpi causa, because he was engaged in a joint criminal enterprise of dangerous driving, and so he couldn't recover anything from the defendant, who was also involved in the joint criminal enterprise. It's quite a helpful case for that point, but also two other points which the Court of Appeal had to consider. Firstly, the defence of volenti was precluded under section 148.3 of the Road Traffic Act 1972. So in passenger cases, you can't argue that the passenger had voluntarily assumed the risk of negligent driving. That doesn't afford a defence. And the second reason it's interesting is that the judge, the trial judge that is, held that the claim was barred on grounds of illegality, but he also said that Mr. Pitts was 100% contributory negligent. And the Court of Appeal didn't like that. They suggested that it's not really possible. The Law Reform Contributory Negligence Act requires some apportionment between the parties, so it's illogical to say that 100% contributory negligence can be applied. Next case is McCracken and Smith. The claimant, Daniel McCracken, was known to the police, his family was known to the police for riding trial bikes illegally all over Carlisle. And he, one day, walking home from school, I think, got on the back of Mr. Smith's motorcycle, and they were riding down the cycle track that you can see just in front of that wall. And the crash happened here. They were going on the cycle track, and as they were crossing that entrance that you can see in the picture, a minibus turned right into the entrance across their path. So there were two negligent parties here, Damien, the driver of the motorbike, and the minibus driver. Now, the trial judge allowed the claimant's claim, essentially by dissociating the claimant from the criminal dangerous driving. So the trial judge said that the claimant wasn't really at fault for the dangerous driving. He was just along for the ride, and he wasn't encouraging Damien to drive dangerously. And so on that basis, he distinguished Pitts and Hunt, where there was active encouragement of the dangerous driving. The Court of Appeal disagreed with that. They said by getting on the motorbike and also by staying on the motorbike when there were opportunities to get off, the claimant was encouraging Damien to ride dangerously. So he was engaged in a joint enterprise of dangerous driving, and therefore he couldn't recover against Damien. As against the minibus driver, however, things were slightly different, and the claim did succeed. The Court of Appeal said that the illegal act, the dangerous driving of the motorcycle, didn't have a bearing on the minibus driver's standard of care, and it wasn't enough for one of the causes of the accident to be a criminal act. There were two causes, the negligent driving of the minibus and the dangerous driving of the motorcyclist, and it wasn't enough for one of the causes to be criminal for ex turpi causa to apply. Finally, the last case is a fairly recent one in the High Court, and that's Clark and Farley. Now, this took place on the Mad Mile, which was a path in a forest park that you can see in the top right-hand corner of the screen, where kids used to ride trial bikes up and down this path after dark. The claimant was 15 years old. He was taken to the Mad Mile one evening, and he got on one of these bikes and set off down the Mad Mile. And on his way back, he crashed into Mr. Farley's bike, and he was very badly injured. Now, this case was decided after Patel and Mercer, which is the latest Supreme Court authority on illegality. And Ms. Justice Yip said that Pitts and Hunt and McCracken still represent the law in relation to pillion passenger accidents. So we're still looking at this line of authorities where this situation occurs. It's also helpful because the two-stage test in all these cases was agreed. Firstly, there needs to be consideration of whether the claimant's conduct amounted to turpitude, and if so, whether the claim against each rider is founded on that turpitude. On the facts of this case, what Ms. Justice Yip said was that the claimant was a first-timer at the Mad Mile, and there was no evidence that he knew that the trial bike would be driven dangerously, and he wasn't encouraging the dangerous driving. And in those circumstances, there was no joint enterprise to drive dangerously, so ex turpi causa didn't apply, and the claim succeeded. So thank you very much for listening, everyone. Just to remind you, everyone will receive a copy of the recording of this seminar automatically. It takes about 24 hours to process, but you'll be emailed that after we close. And of course, all recordings of the webinars that we've done to date are available on the website under the Knowledge tab. If you have any questions, we're going to stop sharing our screen now. Please do type them in the Q&A panel. I think I've got 2 already, and I had one already sent in advance. So I'll hand over to Rob, I think, for the first question.
Just to unmute myself, just in case anyone can't see the first question, it's, what is your view of a claimant stepping out and catching the wing mirror of a passing vehicle? What would the apportionment be? Well, I think in response to that, I have to say that I don't think we have enough information with just that. I think what you need to look at is blameworthiness, really, and whether the driver in the circumstances could have done anything different or could have avoided a collision. So there are 5 things I think you need to look at: speed of the car, whether the pedestrian and the driver were adequately looking out for each other, the use of any warning like a horn, visibility in the light conditions, so whether they could see each other, and stopping distances. So I'm sorry to sit on the fence on that, but I don't think we have enough. We've got a second question, and the question is, regarding the pavement cases, might contributory negligence arguments work in a case where a pedestrian was walking on a road without a pavement? 2 things on that, really. I think the point about pavements is that, number 1, vehicles shouldn't be on pavements, and number 2, pedestrians are entitled and are acting reasonably if they're standing on a pavement, to think that they're not going to be in harm's way. And so if you're on the carriageway, then claimants can't deploy those arguments. And really the classic places where you're walking on the road without a pavement are country roads. That comes up quite often. Yes, claimants can be negligent themselves if they're walking unsafely on a country road. And really, I'd ask, I think you need to look at the Highway Code as a good starting point, because there is a section at the very beginning of the Highway Code that deals with rules for pedestrians as road users. And it deals with, for example, if you're on a country road, and I'm assuming a lot here that you're talking about country roads, but walking in a place where you can see oncoming traffic, keeping close to the side of the road, but also doing your best to help other road users to see you. So if it's dark, for example, wearing a high-vis jacket or using a torch. And then for drivers, there are mirror rules in country or rural or narrow roads that deal with being prepared for there being pedestrians or horses or cows or cyclists on the road. And I think the rules, I've looked these 2 up. I think your pedestrian highway code rules are right at the beginning. I think they're rules 1 to 6. And the driver's rules are 154 and 206. So there is some case law out there. I haven't been able to find it in the time we've had. But I would start by looking at those rules and seeing if they apply to your case. Tom, do you have any views at all on those points?
No, nothing to add, really, to what you've said.
Very well.
We had one other question which we received in advance, which was, is there any legal requirement for a cyclist to stop if they've caused an accident and provide their details? Section 170 of the Road Traffic Act gives a legal requirement for the driver of a mechanically propelled vehicle to stop and give their details if they've caused an accident. But there's no equivalent provision, on my research at least, for a cyclist to stop. What we do have is section 168 of the Road Traffic Act, which says any of the following persons, and that includes the rider of a cycle who's alleged to have committed an offence under section 28 or 29 of this act. So that includes careless and inconsiderate cycling, who refuses on being so required by any person having reasonable ground for so requiring, to give his name or address, or gives a false name or address, is guilty of an offence. So essentially, if you're a cyclist and you've been cycling carelessly and someone asks you for your details, then there is a legal duty to give them. But if you can cycle off, then there's no legal duty to stop, on my research at least.
Tom, you can imagine a judge drawing adverse inferences if there's a dispute of fact and the cyclist has done a runner, if you like.
Yeah. Yeah, and it would be difficult, really, particularly on a bike, to try and argue that you hadn't noticed that you'd hit someone. So that'd be pretty damning evidence against you, I think.
All right, Tom. Well, thank you very much, everybody. I hope that was useful. And a few announcements to make. This is going to be sent to you, I think we've said it already, sent to you automatically probably tomorrow. Thank you for joining us. And in terms of next week's seminar, again, it's going to be on Tuesday. And Joel McMillan is going to be giving a talk about employers' liability. So I think that's everything. And I'm going to stop there.